Aloha and welcome to another edition of Condo Insider, Hawaii's show about association living. I want to invite you to call our hotline if you have a question at 415-871-2474. In this show each week, which is every Thursday at 3 p.m., we talk about issues affecting associations. When you think about it, about 1/3 of our population lives in some form of an association here in Hawaii, like a condominium. Today we're going to talk about a very challenging subject, in my opinion. We're going to talk about, number one, smoking in condos, what the board can do and owners' rights. And we're going to talk about the new laws as marijuana, using them in a condo. And maybe we should change our show name from Condo Insider to Cannabis Insider to make this show very special today. But anyway, we're very blessed to have with us today one of the most prominent lawyers in our industry, Phil Nerney, who's been very active not only in the association law practice, but also as the former chairman of the Legislative Action Committee for CAI. And I'd like to welcome Phil to the show and tell us a little bit about yourself and about your firm.
Well, thank you, Richard. I appreciate being here. The practice that I have is focused entirely on the representation of condominium associations. I am a sole practitioner. I have my manager, office manager, and my paralegal.
Does it often drive you to drink doing association management only, or?
Well, I don't drink, but I find it challenging from time to time.
And you were also the former chair of the CAI's Legislative Action Committee. Are there a lot of bills each year on association matters, or?
There are. I appreciate being a former chair rather than the current one because the chair has a lot to do. We all on the committee participate, but the chair has a particularly difficult role during the session.
Well, I know we thank you for your service to our industry, and I know our other members of the committee all work very hard to make sure we have responsible and meaningful legislation. There's always two sides to every view, but from my experience, we see a lot of legislation not based on fact come forward, that we have a lot of work to do to educate our legislators.
I agree with that.
Yes. Well, one of the things that, being a former condominium managing agent, that we get questions on all the time is smoking. We know smoking is a carcinogenic. We know it offends some people, may be allergic to it. What can boards do? What is the law with regard to smoking in condos today? Are there restrictions? Where does the line draw?
Well, if a board wants to eliminate smoking at a project, there are areas of responsibility that the board has, and then there are areas of responsibility that all the owners have. And with respect to the common elements, the open areas and other areas apart from the individual unit, the board typically will have jurisdiction. Some project documents are more restrictive or less restrictive, but broadly speaking, the board of directors can take action through rulemaking with respect to common elements. With respect to the units themselves, you can perhaps regulate the impact of smoking outside of the unit. Smoke leaks and goes into somebody else's unit or into a hallway, but this behavior within the unit itself is beyond the reach of rules. So you would have to amend your project documents if you wanted to go that far.
So talking about the common elements first, which would be, the swimming pool, the elevator, the lobbies. What I hear you saying is that basically, under today's law, that you can't smoke, that the state statute provides for no smoking.
Well, as a matter of state law, as opposed to individual condominium governance, there is a restriction near entrances, exits, windows of a 20-foot presumed distance of minimum reasonable distance. So you shouldn't smoke near entrances, near windows, near intake vents, things like that. But state law restrictions are separate from private covenant restrictions that a condominium or association board could enforce on their own.
So in expanding it beyond the state law on the common elements through rulemaking, they could prohibit smoking if they so chose.
Indeed.
Indeed.
Condominiums.
Well, some projects, are mixed use projects. And so they'll have like restaurants or other things. I would assume that the smoking laws we have currently for our public restaurants, since that's a public facility in a condominium, that those rules would also apply to those particular condo apartments.
Well, the public areas are going to be subject to state law because I think it's chapter 328, I forget, relates to public areas.
Right.
And so you're going to have, even in a mixed-use condominium, some areas that are going to be regulated by statute, but then you're also going to have other areas that are just going to be the private governance of that association.
One of the things I've seen, because all these condo documents are all so different depending what generation and year they're put into effect. You'll find what I'm going to call the lanai.
Yeah.
And the lanai is sometimes in the documents are part of the apartment. Sometimes it's a limited common element, which means it's a common element limited for a specific owner's use, in my opinion. And in addition to that, you find sometimes that the lanai is a common element, but the airspace is restricted to the owners. And I'm probably missing a few of the other alternatives. What can the board do with lanais?
Well, I think that legal opinion diverges with respect to lanais. They're the hard question. I personally have a view that regulation is possible with respect to lanais. Your initial point, though, about the project documents being different, that's where you have to start. You have to look at what your project documents provide. That'll give you guidance as to what your regulatory authority is. My general view, though, is that if the smoking on the lanai, regardless of how it's classified, causes an impact towards others, that provides the basis for regulation, enforcement activity by the board of directors.
And your view is based on the fact it's not the smoking itself, it's the fact that the noxious odor from the smoke goes to another apartment or area that offends somebody, and based on that, you can possibly control smoking on the lanai.
Correct. So you can look at that basically two ways. Most condominium bylaws prevent nuisances, either literally by that word or what amounts to a nuisance theory language that supports a nuisance theory. And you've just described a nuisance. I'm sitting in my own home, but I can't enjoy it because smoke is wafting in from somebody else. And then there's also typically language about quiet enjoyment, which is similar to nuisance theory. And in both of those cases, that's subject to regulation.
So just to kind of expand on that so our audience can understand it, I know that I had an association, and on its outdoor lanai, a first floor unit owner who happened to work for a cigar company incessantly smoked cigars all day long, so that noxious odor was affecting the enjoyment of the other residents, depending which way the wind blew that particular moment in time. You're saying that based on that, the fact that the noxious odor is causing discomfort and loss of quiet enjoyment, the board may be able to impose rules preventing him smoking his cigar on the lanai.
That is my view. You have to consider that there's a social aspect to condominium associations, and there's also a political aspect. So many of these things that you have to regulate, you need to run through the filter of what the expectations of the community are, as well as how it's going to go down politically with the body politic of that association. But yes, regulation in that circumstance, to me, sounds very simple. I'd be happy to help that association.
Well, good. One of the interesting things is I believe an opinion was written by our Attorney General previously, which supports your view that they can control these smoking on lanais, but in the end, you end up sometimes litigation, and judges usually have a stronger position than the Attorney General, the attorney sometimes, that they make rulings sometimes, so I guess it's never known, and we certainly would advocate owners and board members trying to solve these problems among themselves without getting into any kind of litigation.
Could I just say on that point that under the condominium statute, boards can enact a policy that requires owner-owner disputes to be mediated between the owners prior to bringing the issue to the board. So in some circumstances, it may be helpful to have the boards make that requirement, not just with smoking disputes, but in a variety of neighbor-neighbor dispute settings.
Do you think Act 187 would apply for that type of a dispute? That's the new, as for the people who are watching, that's the new statute that was enacted where we use evaluative mediation, which, by the way, our guest is an expert on, through the real estate education, continuing education fund, help subsidize this. You think Act 187 would be viable or an option for smoking issues?
I think it's perfect for it. And when we, through the committee, sought to ask the legislature to implement that kind of approach, our notion was that if there was a professional cadre of mediators and mediation service providers that were getting involved, that we could take on more complicated disputes. People who can deal with more nuanced problems and issues by virtue of the fact that they have an understanding of condominium structure, practical reality, and law.
So going back to my cigar smoking friend, if he says, screw you, I'm not going to do anything, I'm just going to smoke every day, what are the board's options?
The condominium law and typically project documents all require compliance with the documents. So that's where you get your distinction between the bylaws and the rules. Bylaws have a greater force, perhaps, in many cases. But certainly if you're seeking to enforce the bylaws, you can ask for compliance, you can reason with the owner, but ultimately, if you have refusal and you need compliance, court is your answer, and the law is very specific that you have to comply with the project documents.
And of course, before the court, they could try Act 187.
Indeed, I think mediation is something that everyone should use.
Now, you're a mediator, right?
I do that work.
You find that mediations are successful?
Mediation is a great tool for a variety of reasons. First of all, it works. Many times you can simply resolve the problem. And second of all, even if you don't actually solve that particular problem in one sitting, people have pent up feelings, and this is an opportunity to vent those feelings and to sort of rehearse how their argument sounds when it hits the ears of another neutral person. Sometimes people in their own mind will have a strong view and create a rationale and a construct of what their theory is. And sometimes that works, but sometimes when it hits the real world, it falls a little flat. So the mediation process can be a good testing ground, and even if people don't come to terms in that particular sitting, there's a very valuable education process and allows people to think, do I really want to get into a significant conflict that might not turn out my way?
One of the things I have found on occasion is that some boards are reluctant to do mediation. They feel A, they're right, and B, what is there to mediate? We're right because we have the rules. There's nothing to mediate. And I've always said to boards, I encourage you to go to mediation anyway. Because as you said, it allows people to vet and let off their positions, understand each other better. Do you agree with that? The board should go to mediation just as part of good faith to resolve disputes? Or?
Well, I agree with that on general principle, absolutely. I very much a believer in mediation, and I think it's the way to go. It's economically efficient. It is an appropriate way for a fiduciary to discharge a duty. It has the communal benefits of keeping it all in the family. There are a variety of things that support the use of mediation, including that the current evaluative mediation program involves essentially a tax on our industry, so it's being paid for, and there are readily qualified professional mediators who can provide valuable assistance on a subsidized basis now.
Well, we're talking today with Phil Nerney about smoking in condos and what boards can and cannot do, and we're going to be coming up and talking about the new laws with respect to marijuana in condos and elsewhere. So we're going to take a short break. Thank you.
Aloha, I'm Kaui Lucas, host of Hawaii is My Mainland, here on Think Tech Hawaii every Friday at 3 p.m. We address issues of importance for those of us who live here on the most isolated landmass on the planet. Please come join me Fridays at 3 p.m. Mahalo.
Aloha, my name is John Waihe'i. And I used to be a part of all the things that you might be angry at. I served in government here and may have made decisions that affects you. So I want to invite you in. I want to invite you in to Talk Story with me and some very special guests every other Monday here at Talk Story with John Waihee. Come on in, join us, express your opinion, learn more about your state, and then do something about it. Aloha.
Welcome back to Condo Insider. We're talking with Phil Nerney about condo issues relating to smoking and coming up shortly, marijuana. In the first 15 minutes of our show, we talked about smoking and the board's rights, that they probably have the right in common elements to prohibit smoking. The lanais is not so much the smoking in lanais. The issue is the noxious odor going into other apartments and affecting their right to enjoy their home. And our guest's opinion was basically that boards can control that noxious odor and require things to be done. And now we're going to get into a little bit more about the marijuana law. But first, legislature. Do you see very many laws each year on smoking or in?
Well, we both know that a lot passes through a variety of committees that we have to keep track of. And it is at the outset of every session a bit challenging to know what we should pay attention to and what's likely to fall by the wayside in and of itself. These days, I think we're more tracking themes than particular legislation. Some of the legislation that gets brought again and again doesn't seem to get traction, and we don't end up expending a lot of resources on it. But yes, it's a very busy time every time the legislature is in session.
And having done this for 20 years maybe, it seems like every year we get the repeat of last year in a different form, in a different way, but it doesn't seem to go away, even though it doesn't get passed. And
The concerns remain, and I don't know that the legislature is always satisfied by the status quo, and there are certainly people who call legislators' offices and demand action. And part of that I think there is a difference of perspective is that condominiums are private property, there are private covenants, there are private governance provisions, and there are the courts to resolve genuine disputes. Some of the things that are just nuisance-oriented kind of complaints from people who sometimes are just unable to be elected or have some particular private concern that's not a general, broader concern, don't seem to get their way, and that is sometimes a problem, but I don't personally hold the view that that's a reason to legislate, and so we have to deal with those issues pretty much every year.
can a board or an association prohibit smoking in the apartment itself?
On its own, I think not. I think that at that juncture, you need to amend your bylaws, but that can be done by the appropriate percentage of owners agreeing to the change. When I have clients who do that, I ask them, and I'm often successful in getting basically a delayed implementation period so that people who do smoke and have an investment that's significant can make other arrangements if they don't choose to work within the new regime.
So in theory, then an association with the proper percentage, usually around 67% on a 514B condo,
Yes.
could amend the bylaws prohibiting smoking in the apartments. And that means that those owners who are smokers who bought there earlier would have to then make adjustments and find a way to comply. And your recommendation is to kind of have a work-in period so people have a chance to resolve it. Did I hear that right?
It is. I think it's only fair. Just because the public health argument may favor non-smoking, there are people who smoke, and they paid money for their place, and that's their home. You can't say, well, go live on the street. People need time to make adjustments. They shouldn't have to be forced to sell at a fire sale price. They need a reasonable period to market, and I think it's a matter of basic fairness. At the same time, during a phase-in provision period, you could also say that your smoking cannot cause a nuisance to others, so that they would have to adjust to the extent of closing their windows or taking other action.
Have you ever seen an association set up smoking areas, like, where if you want to smoke, you can smoke, but you have to do it in this corner of the project, or?
Yes, some projects do that, and I think that's perfectly appropriate.
So, recently, we started hearing about marijuana in condos. And so if I'm a person with a medical marijuana certificate, can I smoke marijuana in my condo?
If you have a valid medical marijuana certificate, you can smoke marijuana within your unit unless smoking within units is prohibited smoking for anything, tobacco, anything. So you can't say you can't smoke marijuana in your unit. You could enact a bylaw provision that says you can't smoke in your unit, and as long as it covers all things, then it would apply, with one caveat. The law that implemented that provision also says that nothing in that statute prevents people from requesting a reasonable accommodation under the fair housing laws. So while I think there can be debate there, it is something for boards to be aware of, that even if you do pass a no smoking ban that's total, someone might say, I need it for some particular reason, and then you have a legal issue that you should consult association counsel about.
And I'm probably not the smartest kid on the block about that, because when I grew up, I heard my parents every day never have a cigarette, so I've never smoked in my life. And then number two, I went to military college, so I never experienced recreational drugs in my life. So it's somewhat foreign to me, but as I understand it, that if you had a legal no smoking policy for everybody, which means a marijuana smoker, that in fact there are other ways for them to be able to get their medical needs through either some type of ingestion or shot, or is that right? Or is there other ways to?
Yes, the prohibition is only on smoking. If somebody's ingesting it some other way, then there's no impact on the association, the project, others at the project, so there would be no real basis for regulation, unless there was some behavioral component that went outside the unit.
And not just with this issue of marijuana in the units. You talked about the Hawaii Civil Rights Commission. What is their role in this and other types of disputes here in Hawaii?
Well, the Hawaii Civil Rights Commission would best speak for itself, but generally, as we as condo attorneys experience it, someone will claim often a disability of a variety of kinds, and they'll request what's called a reasonable accommodation. It is necessary to reasonably accommodate disabled persons so that they have equal access to and equal enjoyment of their units and the project. So there's something that's contemplated called an interactive process. If someone says, I need a reasonable accommodation, then you engage with them to determine what's fair for everybody. And at some point you have to make a judgment about whether you're willing to get into a contest with the Hawaii Civil Rights Commission or through the courts from a private advocate.
I know the Hawaii Civil Rights Commission has very strong views on fair housing subjects, and I've always
We both smile.
I know, and I've often cautioned boards and our viewing audience that that this isn't something you should ignore if you get a letter from them, because not only do they have a lot of power, they can force boards to go to training and do all sorts of other things that kind of disrupt your life. And do you share those sentiments? Or?
I would only ignore a letter from the Hawaii Civil Rights Commission if I was a person who would ignore a heart attack. It's a serious matter. It's a matter you need to deal with through counsel appropriately. It can be a very significant burden on the operations of an association, and there can be serious consequences if an association is found to have violated the law.
Well, briefly walk me through. So you're a condo board, and a person comes to you and says they need a reasonable accommodation. You have, in this case, a no smoking bylaw or declaration provision, and because I am also in a wheelchair and all these other reasons, I need to have an accommodation. I'll be able to smoke marijuana in my unit. Walk me through the base, not the issue itself, the basic steps a board should take once they get that notice to create this dialogue or whatever however you want to describe it.
Well, this will certainly sound self-serving, but a board of directors, a resident manager, a property manager, first instinct and action should be to call association council and do nothing in terms of engaging beyond saying, thank you, I've received it, we'll process it promptly. Because there are so many potential pitfalls that can occur that handling these kind of requests through council is the only safe way to go. One general tip for any kind of conflict is the board should not be sending emails to one another. The Hawaii Civil Rights Commission, or in any matter that would end up in court, those communications are all going to be subpoenaed or requested and produced. So if somebody makes an inappropriate comment in an email, which they think is a private communication, that can very much be to the prejudice of the association.
Well, I think your operative words were the first thing they should do is
Yes.
contact their association lawyer and do nothing,
Yes.
because all this email and other types of things can very damage your case. And while we're on the marijuana issue, it's also my understanding, and to be corrected by someone smarter than me, that people who have a medical marijuana certificate can actually grow a certain number of plants within their unit for their own personal use, not for sale, but for their own personal use. So if you even have a situation where your resident manager or security guard has pointed out someone's growing, they should immediately talk to their association lawyer and determine the facts before they go out and make some offhand decision.
Absolutely.
Anyway, we are here with Phil Nerney talking about smoking and marijuana use on Condo Insider. Our show is every Thursday from 3 o'clock to 3:30. We focus on association issues. We want to thank you for joining us today, and we look forward to next week's show. Aloha.